Okay, folks, let's get started. This is a criminal procedure video topic dealing with the right to self-representation. It connects to Chapter 1, Part B of the Miller Right text. Now, at the level of constitutional doctrine, this is about a tiny little case, Faretta versus California from 1975. In Faretta, the Supreme Court declared that just as the Sixth Amendment provides for a right to counsel, that includes the right not to have counsel. That is, it preserves the choice of the defendant. And it turns out that not that many defendants actually represent themselves at trial. On the other hand, this is still a very important doctrine because at the level of mass legal practice, there are two big questions lurking in the background here. One of them is waiver of counsel, not at the trial level, but at the pretrial level. Lots of waiver happens pretrial. And second, in the background of a lot of these Faretta cases is the selection of counsel. You very often get a good window into what a defendant is thinking when the defendant has limited power to select which lawyer is going to represent him or her. Let's jump in. Now let's walk through a case study of Faretta rights in action. State v. Spencer is our example here from Iowa. Spencer wants to fight the charges for growing marijuana, but his retained lawyer, Mock, is not so enthused after losing a suppression motion. Originally they're on the same page, but now Mock says, we don't have anything left to really realistically fight at trial. But Spencer wants to soldier on. And so Mock moves to withdraw days before the trial, and the court appoints a new attorney, McCoy, even though Spencer says, no, I don't want McCoy, I want to represent myself. The trial judge appoints McCoy. The trial is continued until a year later, and this time with McCoy representing him. They go all the way through the trial. There's a jury verdict of guilty, and now Spencer is challenging the legitimacy of this conviction because he says, you forced an attorney on me. Violation of my Faretta right to waive counsel. According to the court in Spencer, accurately summarizing Faretta, it says that Faretta makes self-representation part of the Sixth Amendment right to counsel. Just as you can claim counsel, you can also waive counsel. It's a defendant autonomy or defendant control right. In addition, under federal law, under McCaskill versus Wiggins, a 1984 case, the judge can appoint standby counsel as long as the judge explains standby counsel carefully to the defendant. Now, standby counsel would be somebody who's a living law librarian, who's just sitting behind the defendant during trial, does not make objections, does not initiate anything, but if the defendant turns and says, hey, what's going on here, the standby counsel can provide backup for the defendant. That plainly was not what was going on with McCoy here, at least by the time of trial, because as the Iowa court says, Attorney McCoy fully represented defendant prior to and during the trial, close quote. Now the Iowa Supreme Court here says this is fine. What happened at trial court here was consistent with Faretta. How did they reach that outcome? One thing that they don't do, a very common move but not available here, is to look at the timing question. Very often a trial judge will say, yeah, I know you want a lawyer, but it's too late. The trial is going to happen tomorrow or within a week or two, and it's just too late to switch to a different lawyer. Because of this 10-month gap, the timing can't be the basis for denying Spencer's request to represent himself. So what does the court say? They end up saying, we think really he did come around to the idea of having a lawyer in the case. He was unhappy initially, but he came around to it. Notice the quotes that we have from the different hearings. I feel I'd be better off defending myself. The judge says, does this arrival of a new attorney meet with your approval, Spencer? And Spencer says, it doesn't meet with my approval, Your Honor, but if you're going to force it on me, I'm going to have to take it. So we have some very clear statements from Spencer that he's not interested in this, but the court's willing to go with his silence at trial as an indication that he changed his mind. You see this over and over in the appellate case law here, with appellate courts upholding trial court decisions to bring a lawyer into the case over some level of reluctance from the defendant. Is it fair to say that Faretta rights no longer exist in Iowa? That might be an overstatement, but it is clear enough that the rights are, that self-representation rights are very narrowly defined, limited by trial courts, and appellate courts are fine with that very limited reading of Faretta rights. Think of this as a mystery. Why would a trial judge rule and the appellate court affirm that Spencer couldn't represent himself? I think the answer to the mystery is that Faretta rights don't have any real constituency. None of the regular players in the courtroom are enthused at all about Faretta rights. Judges hate it. Trial judges hate it, and appellate judges understand why trial judges hate it. It slows down the proceedings. It makes for odd rulings. A trial judge is supposed to rule on motions and so forth for self-represented defendants, the same as they would for those represented by counsel, but in practice it really doesn't work out that way. You're always having to put your thumb on the scale, and it's just an appellate nightmare. It just makes for a lot of issues on appeal if you don't have that defense attorney in the room. Defense lawyers hate it, of course. It produces just train wrecks and injustice at trial. You don't want to look when you see the occasional defendant who comes along and successfully asserts Faretta rights. It's not a pretty sight. Even prosecutors are equivocal about it. Some are okay with, hey, this makes my job easier, but a good number of prosecutors say, this actually makes my job harder. There's no telling what is going to happen on the other side, no telling which of these crazy motions that the defendant is going to come up with is going to produce some kind of uncertainty on appeal. I'd rather have the predictability of a defendant on the other side. Indeed, I'd rather have the quality of justice that's going to come from having a defendant on the other side or a defense attorney on the other side of the case. Now, it seems to me that the public may have an interest in capable defense attorneys being involved in the case. Does that mean that the defendant should not, in fact, have Faretta rights, that the court should overrule Faretta? Would overruling Faretta actually be in the interest of defendants? After all, the old saying is, the person who represents himself has a fool for a client. This is captured very nicely in a Woody Allen movie from 1971 called Bananas, where he represents himself to funny effect, but it's not justice happening. Take a quick look.
Call Fielding Mellish.
Mr. Mellish, what is your nationality? Well, you might say I have two nationalities. Are you being coy? Well, I am an American citizen and also the president of San Marcos. I would not joke with this court if I were you. Wouldn't you, or couldn't you?
That's enough.
Does the code name Sapphire mean anything to you?
So Woody Allen gives us one vision of the defendant representing himself, spinning around, making a fool of himself, completely ineffective at trial, although funny. Actually, in reality, it's sad to see this happening. But there are other visions of defendants representing themselves at trial, those who might be more effective than their attorney. And you get some little glimpses of this in a few studies. Erika Hashimoto has done a nice study of Faretta rights and finds some evidence that pro se defendants had stronger outcomes than represented defendants. Some defendants who represent themselves do pretty well. There's also some evidence from measures of quality of defense counsel that I've done with my colleague Ralph Peoples, where we find that in a given jurisdiction, based on our effectiveness rating, the defendants who represent themselves are not consistently at the bottom of the stack when it comes to effectiveness of defense counsel. A couple of snippets of evidence suggest that it's not always a disaster. That being said, the prominent cases that make the news are not pretty sights, and we do see defendants who are not being terribly effective, at least at trial. Now, this Faretta doctrine has a relatively small footprint in criminal justice if you're looking only at the world of trials. But if you look at the world of pretrial proceedings, waiver is a much bigger deal. You have far more defendants going forward without a lawyer pretrial. In felony cases, it's actually pretty hard to figure out exactly how many defendants waive counsel pretrial. A close look at some North Carolina statistics suggests that it's something like 3 to 4% of felony defendants. But notice what happens in the world of serious misdemeanors. And these would be cases where some kind of prison term would be available, where there would be both a state and a federal right to have counsel, and yet the waivers are, depending on the type of misdemeanor, somewhere between a third and a half of all the cases. Enormous numbers of defendants. How does this happen? In the world of pretrial proceedings, especially for misdemeanors, trial judges' attitudes are just the opposite of what we saw in the Spencer case, where the trial judge is trying his or her best to get a defense lawyer into the case. In the world of pretrial proceedings and misdemeanors, the trial judge is much more open to waiver, indeed might even be encouraging waiver. So it may be that the trial judge, say at arraignment, has waiver forms spread out on the table and encourages people to sign the waiver form as just a routine part of arraignment. It could be that a state has an upfront fee or a representation fee that is charged to all defendants across the board, maybe only $25 or $100, but still, put some kind of money up front. It has some good effects in terms of creating a more invested relationship with the defense attorney, but it also encourages more waiver. Waiver through various subtle methods is more tolerated, even encouraged in the misdemeanor context, particularly pretrial. Faretta motions are also interesting and important because they give us a window into something going on in most cases, and that is the reality of some tension between the defense lawyer and the defendant. Lots of Faretta motions are not so much claims by the defendant that I want to represent myself, but a claim that I'm frustrated with my current lawyer. I'd like a different lawyer. It's difficult for a defendant who has not retained his or her own counsel to switch lawyers. In the crude but accurate phrase of the court from State versus Green, beggars can't be choosy. That's not the way many courts would put it, but it is the outcome. That is, when defendants say, I want to switch from lawyer A to lawyer B, but they're both appointed by the court's going to be very reluctant to do that. You can see why some defendants would get into some tension with their defense lawyer. They see the prosecutor paid by the state, the judge paid by the state, and if it's a public defender, the public defender paid by the state. It looks like they're all out to get me. I want a real lawyer. Lots of public defender offices notice the irony here of their clients not being especially happy with the situation, and in very many of these offices you'll see posted in the office somewhere a quote from some defendant saying, I want a real lawyer, not a public defender, or as sometimes they're called unkindly by their clients, a public pretender. I happen to think that this view is completely unfounded, but nevertheless, it's a reality of the relationship. There's some tension there that good public defenders have to work through with their clients, and it's not always successful, and so the Faretta motions reflect some of that lingering frustration. Okay, when we get together next time, we'll be talking through these questions of waiver and selection, and then we'll move on to ineffective assistance of counsel claims. We'll talk later.